Constitutional Court has upheld the 2018 Labour Court ruling on the public sector wage bill. For more on this, we're joined by the National Education, Health and Allied Workers Union President, Mike Shingange. Mr. Shingange, thank you very much for joining us this afternoon. COSATU has called this ruling regrettable. How would you characterize it?
Yes, good afternoon to your viewers. Indeed, it is very regrettable because it throws out the window the principle of collective bargaining. We understand that the courts have done their job. We actually disagree with some of their rulings, but something that we cannot do anything about it because it's now in the Constitutional Court. However, we do think that the matter doesn't go away because the fact that the state owes its employees arising from a collective agreement that has been signed in the same parameters that the other agreement have been signed doesn't go away. The fact that there's an institutionalized relationship between employer and employees that has to continue beyond the court judgment doesn't go away, and it's going to complicate the next round of negotiations. It's also complicate the manner in which the negotiations are going to take place in the public service. So therefore, it is regrettable, but we think that the government could have handled this matter differently. But obviously, workers, after considering all the factors in the judgment, are going to have no choice but to come up with what is it that is a way forward to try and claw back and recoup the wages that they've lost in 2020.
I'd like for us to expand when you say the issue doesn't go away and it complicates the next round of negotiations. Meaning what?
No, if you owe me, me and you have got into the agreement that this is how you are going to pay me, and suddenly something happens to you and you go to court for the court to say to you, you can walk away from the debt. The fact that you owe me doesn't disappear. If me and you have a relationship, a business relationship for that matter, the fact that the court will rule against you or against me does not mean that we have no responsibility to come back and deal with our relationship. That's why the matter doesn't go away at the moment. The fact that workers were treated, were coined by the state to sign an agreement for 3 years, even though they wanted to sign a 1-year agreement, hoping that they are going to give the state a breathing space. And they paid 2 years and they're not paid on the last year. Doesn't mean that workers are not owed the last year leg of. Whether legally the court says something else, it doesn't mean that the next time we look at my employer in a workplace, the next time we meet with the employer in the bargaining council, the first thing that is going to come to my mind is that I'm engaging with a disingenuous employer, a person who can't be trustworthy. The trust relationship has now been broken down irrevocably because it has now been handled by the court. So that's the issue that the courts will have no space to play, but ourselves, we have to deal with this thing. And that it doesn't order well for the public service and the fact that these public servants are supposed to continue to deliver service to our people at this time of the need. In fact, the morale of the public service, much that has been demoralized over the past 3 years, we think today's judgment actually crashes them to the bottom line.
What options are then available to you on behalf of the workers? Is industrial action on the cards?
Well, there are a number of options. Some of them will want to consider them after intensively studying the judgment. As you know, it's only over an hour ago that the judgment was issued. But one of the things that is on the table is that you remember that we had signed a 3-year agreement that was supposed to have ended in 2020. Now the court says that agreement was invalid and unlawful, therefore unenforceable. It means, therefore, there were no demands. There were no agreement. It therefore means our demands that were there, that we had to compromise them because of the state pleading that they can't afford what we're demanding. The fact that we have wanted a 1-year agreement and we ended up signing a 3-year agreement, it must mean that we might look into reinstating those demands and start negotiations afresh. But secondly, is that this round of negotiations that is coming now for 2022-2023 will have to take into account the effects and the impact of this judgment, because what this judgment means is that you're asking workers to forfeit a conditions of service or a adjustment of a cost of living of 2020, something that no worker can afford. So these options are still out there. Of course, the industrial election, once we go back to the negotiations and we don't agree, remains an option for workers every time.
Just maybe a final thought from you. You mentioned a little bit earlier on that government could have handled this in a different way. What do you believe they could have done differently?
We're saying that if it is poverty, if the lack of money they are pleading, you don't go to court and ask that court must exonerate you. You negotiate with the person that you have got an agreement with. They could have done that. But secondly, they have always misled the public servants in particular, and the PSCBC that were negotiating with people that have got authority to negotiate with that. It is clear now that when it suited them, they then ran and evoked a section in the Public Service Act that actually it's supposed to be the Minister of Treasury that we negotiate with. The employer of the public servants, as far as we've always known in terms of the Labour Relations Act, is the Department of Public Service and Administration. Now that the Treasury is supposed to be the one who gives consent on and what to be signed or not to be signed, it means, therefore, henceforth, we need to find a space for the Treasury to be the one who leads negotiations in the collective bargaining. So this matter is complicated. They could have handled this matter a long time ago, and they could have negotiated the repayment terms, even if it's on a staggered manner. But for them to hope that legally they must be told that they can walk away and everything must go as business as usual, I think they're very mistaken, because this matter, there's no way that for as long as workers live, this matter they're going to forget.
Thank you very much for availing yourself. Mr. Mike Shingange is the president of the National Education, Health and Allied Workers Union, Nehawu.